A very warm welcome to the official channel of Erudition Law. Today we will be talking about the general exceptions as discussed under the previous IPC and the now BNS. It is chapter 3 of the new act, which is the Bharat Nyay Sanhita, and I will be discussing the whole chapter. This is the first part of the video. Hope you enjoy the session. Now, before getting into the part of exceptions, let us first understand why is there a need for this chapter? Why do we need chapter 4 in the Indian Penal Code at all? For that, we need to understand one very traditional basic Latin legal maxim which lies at the basic foundation of criminal law both under the common law system in England and under India, which is this one: Actus non facit reum nisi mens sit rea, which when directly translated to English would mean that an act to become a crime has also to be supported by an evil intention or an evil motive. Now, this seemingly difficult maxim will become very simple when I break it up into two parts, that is actus reus and mens rea. You would be interested to know this, that these two are the actual ingredients of a criminal offense. Without these two, there cannot be a crime. Even if one goes missing, then also it will not become a criminal offense at all. That is, it will not be punished, it will not be culpable by the Indian Penal Code. So let us understand the meanings of these ingredients. The first one is actus reus. Actus reus is the physical part. It is the act that you are doing. Suppose I am mixing poison in someone's food because I want to murder that person. I want to kill that person. My mixing of the poison in the food in this case will be the actus reus. That is the physical act of the crime. What is mens rea? Of course, you have guessed it correctly. Mens rea is the mental part. It is the intention with which I am trying to kill you. My intention, my motive is to put the poison in your food and give it to you, but my basic intention is actually to murder you, to kill you. So you see how both these are important, actus reus and mens rea. I have to mix if I think about mixing the poison, suppose I just have the intention of killing you, but I do not mix the poison, then of course it won't be a criminal act because there is no actus reus only. Similarly, there is actus reus. I innocently give you a poison laden food. I do not have any intention to kill you. In fact, I do not have knowledge of that food containing poison. So there is no mens rea, so then also it will not be a culpable offense. This forms now the basic foundation of criminal law under the IPC. Now, why are we discussing this before starting the general exceptions? Because the theory of mens rea has been inculcated in two ways into the provisions of the Indian Penal Code. The first one is very direct, by using the words like dishonestly, voluntarily, fraudulently, reasons to believe, etc., which directly tells you reflection of the person's intention. For example, if I talk about section 379, which defines the offense of theft, there very easily it has been defined that whoever takes dishonestly anything from the possession of another person without his or her consent. So see how the term dishonestly has been used and how it makes it very evident, very clear that it has been done with an evil intention, and so there is a presence of mens rea, and because there is a presence of mens rea, it will be a punishable offense. And the another way, which is general exceptions under chapter 4, is the indirect way by which mens rea has been included in the IPC. How is that? This tells us of those provisions where we have the act, but due to lack of mens rea, it is coming under the umbrella, the protection of exceptions. As you can see here, of course we will be doing each of these provisions in details, but as you can see here in the chart that I have prepared for you, there are two types of such act that will get this protection under chapter 4 of the IPC. The first one is an excusable act and the second one is a justifiable act. Now, how do we define excusable act? Very simple, where your act can be excused. Now of course you will ask me that why will my act be excused when we are talking about criminal law? Of course, because there is no necessary mens rea. The necessary mens rea is lacking in these cases. That is why they are called excusable act. That is, they are excused in the eyes of law. What are the acts under this? Mistake of fact, incapacity, which is again of three types: infancy, insanity and intoxication, and finally we have accident. Similarly, the other kind of act that we talk about whenever we are talking about the exceptions to criminal law, we have justifiable act. What is the difference between excusable act and justifiable act? Excusable act is when the necessary mens rea is lacking. Justifiable act is when the law in itself is telling you to do that act, and it is very much justified also. You are doing that act in the eyes of law are the justified actions of any human being. That is the difference. Here mens rea does not play a role directly. Of course it plays a role. No one can do anything under the purview of taking a revenge or a grudge and can use mens rea, lack of mens rea as an excuse. Of course not that, but this is indirect. Whereas in excusable act we find the application to be much more direct. So let us now get into each of these provisions. The first one is mistake of fact, and the sections are 76 and 79. Now whenever we are talking about a mistake of fact and a mistake of law, the first thing that you need to know is what is a fact and what is a law. Very simple. A fact is anything that you can perceive with any of your senses. You can see something, you can hear something. These are all facts. See, I'm sitting here and talking to you right now. This is a fact because this is something you can perceive with your senses. This is fact. What is law? Law is something that the state is giving to you in the form of a statutory act, and you have to follow it. When you're not following that act, you will be punished by law. This is the difference between a fact and a law. Now let us get into mistake of fact and mistake of law.